This training explains basic legal requirements of mandatory child abuse reporting for the City of Portland employees. The training will last about 15 minutes.
This training covers the following topics about mandatory child abuse reporting. Why does Oregon have a mandatory reporting law? Who is a mandatory reporter? What is their responsibility? What is child abuse under Oregon law? When is a report required? How is a report made? What are the consequences of not making a report when the report is required? How can I get more information?
Why does Oregon have a mandatory reporting law? By its mandatory reporting law, the state of Oregon has declared that the health and safety of children is so important that mandatory reports and investigations are necessary.
All 50 states have some form of child abuse reporting laws. The laws are designed to encourage mandatory reporters to identify children who are at risk and to respond by notifying agencies who are responsible to see that the children are safe.
In 2017, the Oregon Department of Human Services, or DHS, reported more than 11,000 children were found to be victims of abuse and neglect in the state of Oregon. Of these, almost half were under the age of 6 and 30 children died.
All Oregon citizens have a responsibility to prevent child abuse and to protect children. Everyone is encouraged to report suspected abuse to the Department of Human Services or to law enforcement.
However, mandatory reporters, those people required by law to report child abuse, are a crucial link in the system to protect children.
Approximately 75% of child abuse reports come from mandatory reporters. In many cases, reporters are the only people outside the immediate family who have regular contact with the children.
Who is a mandatory reporter? In 2012, the Oregon Legislature passed a new law.
Employees of public organizations providing child-related services or activities were added to the list of mandatory reporters of child abuse.
This means that all City of Portland employees are mandatory reporters effective January 1, 2013. Both the Multnomah County Council Office and the City Attorney's Office interpret this law as covering all City of Portland employees. When is a report required? As a mandatory reporter, the law requires you to report if you have reasonable cause to believe that abuse has occurred and you have had contact with the child or the abuser. It is important to emphasize that as a mandatory reporter, your duty to report is 24 hours a day, 7 days a week.
In other words, you are not only required to report abuse that you become aware of in the course of your job, you are also required to report abuse that you observe on weekends, in your neighborhood, at the children's schools, and in their sports activities. The duty extends to any child abuse at any place at any time. What constitutes abuse under Oregon law? Child welfare professionals often talk about both abuse and neglect because abuse is usually an action taken against a child and neglect is usually a lack of care. Oregon law includes neglect as a category of abuse. So when you hear the term abuse, keep in mind that it refers to both abuse and neglect. The term abuse includes threatened harm, physical abuse, neglect or mistreatment, sexual abuse, and mental injury. We will go through each of these terms in the next slides.
Threatened harm involves exposing a child to any activity, condition, or person that creates a substantial risk to the child's health or welfare. Some examples of threatened harm are domestic violence, the presence of a sex offender barred from being in the vicinity of children, drug use that impairs the ability to take care of a child, and driving a child while under the influence. In addition, exposing a child to a controlled substance that subjects the child to a substantial risk of harm, including permitting a child to enter or remain in a place where methamphetamines are manufactured, constitutes threatened harm.
The physical abuse of a child is another form of child abuse. Oregon law defines physical abuse as any injury to a child which is not accidental. This category includes unreasonable discipline and delayed or inappropriate medical treatment. Most parents do not intend to injure their children, but it's important to note that abuse is defined by the effect on the child, not the motivation of the parents. Oregon law permits parents to engage in reasonable discipline. The law permits the use of reasonable physical force but does not give license to inflict an injury on a child. Reasonable discipline does not constitute child abuse unless it results in the type of injury or treatment described in this section. For example, some signs of physical abuse that are not reasonable physical force includes bruising that covers many areas of the body or that reflects the shape of an article used to strike a child, or cigarette burns, immersion burns that have a sock-like or glove-like pattern, rope burns on the arms, neck, or torso, and lacerations of the mouth, lips, and gums.
Another form of child abuse under Oregon law is neglect or maltreatment. Under Oregon law, failure to provide food, clothing, shelter, or medical care that is likely to endanger a child constitutes child abuse. A home that is unsafe or unsanitary may also be a form of child neglect or maltreatment. It is also a form of neglect or maltreatment to provide inappropriate supervision or protection for a child. Under Oregon law, it constitutes criminal neglect for a child under 10 to be left alone. Oregon Child Welfare has provided guidance that a 12-year-old can be left alone and care for other kids. Neglect is typically a long-term issue, but it can be a single serious incident. Signs of neglect include consistent hunger, poor hygiene, inappropriate dress, and begging or stealing for food. An example of a form of neglect or mistreatment may involve leaving a child alone in a car. Whether it constitutes neglect or mistreatment would depend on the outside temperature, whether the child is crying or sleeping, how long the child is left alone, and how old the child is.
Any form of sexual abuse constitutes child abuse under Oregon law. Any act that constitutes a sex crime under Oregon law is included in the definition of sexual abuse. This includes rape, sexual assault, and any adult who has sexual contact with a minor who is 3 or more years younger than the adult. Sexual abuse also includes the sexual exploitation of a minor. Sexual exploitation includes allowing a child to perform a sexually explicit act for an audience or to be photographed depicting a sex act. Allowing, encouraging, or hiring a child to engage in prostitution or to patronize a prostitute who is a minor also constitutes sexual exploitation. Finally, sexual exploitation includes buying or selling a minor.
The final category of child abuse is mental injury. Mental injury is cruelty that results in observable and substantial impairment of the child's mental or psychological ability to function. It may involve repeated screaming or disparaging of the child.
When is a report required? Mandatory reporters are required to make a report of child abuse if the reporter has reasonable cause to believe that child abuse has occurred. Although there is no clear definition of what constitutes reasonable cause, some things are clear.
You do not have to be sure that abuse occurred before making a report. Your report is a request for an assessment to be made. Sometimes child welfare will gather additional information and determine that abuse did not occur. It was still appropriate for you to make a report.
If you have questions about whether or not to report, please call a local child welfare office to consult with them. They can tell you if it's a situation that should be formally reported.
What constitutes contact with a child? Mandatory reporters are only required to make a report if they have had contact with a child or a suspected abuser. Clearly, if you have had direct personal interaction with a child or with a person suspected of abusing a child, you have a duty to report if you have reasonable cause to believe that the child is being abused. Other forms of contact, including indirect contact, may also give rise to a duty to report. Examples of indirect contact may include email or phone contact with the child or with the abuser. Contact may even come through a social media site like Facebook, Instagram, or Snapchat. Though these forms of indirect contact are not clearly covered by the law, a prudent mandatory reporter would make a report to child welfare even if he or she had only indirect contact with either the child or the abuser.
What if the abuse happened a long time ago? It is important to note that the concept of contact does not require that the mandatory reporter has directly observed. And even if the reported abuse happened a long time ago, you should still report it. The abuser may have access to other children, and the earlier history may be important in preventing further harm or abuse.
How do I make a report? The first thing to know is that the statute refers to making a report immediately. It is important for mandatory reporters to not unreasonably delay making a report to the local child welfare office or another agency designated to receive such reports. Such a delay would violate a mandatory reporter's duty under Oregon law to make an immediate report. Mandatory reporters may make their report orally by phone or in person to a local child welfare office or to law enforcement. The phone numbers for the Portland metro area are listed online. In an emergency, you should call 911. What information should I have? When making a report, you should provide as much information as possible. Relevant information includes the names of individuals involved, their ages, the location of the abuse, and a description of the abuse. You should make a report even if all the information isn't available to you. Your duty is to provide whatever information you can about the suspected abuse.
Is a report confidential? Generally speaking, the fact that you made a report is not released to the public and is not accessible to the alleged perpetrators of the abuse. However, you might have to testify at juvenile or criminal court proceedings about the abuse.
Should I make a report to my supervisor? As a mandatory reporter, you must report to child welfare or a law enforcement agency. Telling your supervisor does not fulfill your legal obligation. However, your bureau may have internal policies asking you to inform your supervisor or other staff members. That is fine as long as doing so does not cause an unreasonable delay and as long as you make a formal report to child welfare or law enforcement. Check with your supervisor to find out your bureau's policy regarding reviewing your report with a supervisor before calling in.
Can I be sued for making a report? It is important to know that there is immunity under the law if a mandatory reporter is made in good faith and there are reasonable grounds to make the report. Given the legal protections for making a report, it is always best to err on the side of making a report in situations in which suspected child abuse has occurred.
What if I don't report? Under Oregon law, the failure to make a child abuse report is punishable as a Class A violation and may include up to a $2,000 fine. There is also a possible tort liability for failing to protect a child from foreseeable harm, and particularly serious instances may even be prosecuted under Oregon law as a failure to perform the duties of office. Although there is potential for punishment for failing to comply with your mandatory reporting duties, the most important reason for you to make a report is to protect the child from further harm. In some cases, you may be the only person who is aware that the child is endangered. Although your report may lead to the punishment of the abuser, it may also lead to a family being provided with additional resources and professional help. Am I required to report child abuse that occurs in another state? Oregon law is not clear with respect to incidents of child abuse that occur outside Oregon or involving abusers and victims who were not in Oregon. Since the law of the other state may also make you a mandatory reporter, you should contact the local child welfare office or local law enforcement if you witness suspected child abuse.
Here is a current list of phone numbers. These phone numbers are also listed on the BHR website.
Thank you for completing the training on this important issue. Remember, it's up to all citizens to help prevent child abuse and neglect.